This is when I think that's going to hit most people hard. And we're going to bring in some criminal defense attorneys to be able to speak on this. But as a former prosecutor in Hillsborough County, I can tell you that this is a big deal. And what it talks about is that they're now changing the law. If you get stopped for DUI suspicion, meaning driving under the influence, in the past, you could refuse to take the breathalyzer test. And what would happen is you would lose your license for up to 1 year, but you'd be eligible for a hardship, work, church, school, etc. Now, what the state of Florida has done is that they're going to charge the refusal of a breathalyzer as another crime. Say you're stopped for DUI. Let's say you've had 2 beers. It's legal to drink and drive. You just can't drink to the impairment level. The officer says, hey, I'd like you to do some field sobriety exercises. And let's say you performed them well. And the officer says, I'd like you to submit to a breathalyzer test. You say, hey, I'm not really comfortable with that. I don't really understand what's going on. Now the officer is going to be able to tell you, if you refuse to take this breathalyzer, you're now going to be charged with a crime. So think about that from a civil rights situation. May I search your car? You have the constitutional right to say, no, you can't. Under this theory of this new law, it would be like, well, because I can't search your car, I'm going to charge you with a crime. Because I'm not going to self-incriminate myself, because you haven't met a legal standard of probable cause as to why you should be searching my car or having a search warrant. Applying that to the same law for this new DUI law, I can't think of a better example of duress. You have somebody which has been legally stopped, and a law enforcement officer is telling them that they are going to charge them with a crime if they don't comply. Telling them that they're going to charge them with a crime if they don't literally give them additional evidence. It's unheard of. It's never happened in the state of Florida. My question is, let's say you have somebody on field sobriety exercises, right? Let's say they nail the alphabet test. One time when I was a prosecutor and we were reviewing a video for arrest, we had a damn cheerleader. You know what she did? She said, I'm not under the influence. Let me show you. She broke off a back handspring and a backflip. And I turned around to the intake attorney and said, I can't believe you charged this woman with a crime. How in the world are we ever going to get a guilt or a prosecution? So imagine that. Officer, in his discretion, maybe doesn't like the way you're talking to him. Maybe says, hey, I can't get them on the DUI. They could simply say, will you take a breathalyzer to prove you're not DUI? And if you don't, you're getting charged with a crime. This is trouble, man, coming down the road. I do think this is a game changer. I think you're going to see some challenges to this once the arrest starts coming down. I think you're going to see this hit the DCA. I think this could go even bigger than that, because ultimately, very difficult for me to wrap my head around, even as a former prosecutor, to say I'm invoking my right not to incriminate myself, and because I'm doing that, you're going to charge me with another crime.